Hello, everyone. This is Tom Fox back again and with a now familiar face on the pod, but this time with an emergency pod. So, welcome back, Jonathan Wilson.
Thank you, Tom. Great to you.
Jonathan, we've had the chance to visit 3 or 4 times or 2 or 3 times over the past 6 weeks now around the Corporate Transparency Act, one of your areas of expertise. And we had as insane a 24 hours as we've had in any of the previous 6 weeks over the last 24 hours. So I ask you if you could hop on a pod today so we can try to get the information out to people. I thought we were going to have one podcast before I woke up this morning. And then I thought, well, maybe we're going to have a second. And now I'm not sure if it'll be a third. So maybe you could start with what happened initially at the Supreme Court, because I thought that was straightforward.
Sure. So, what the Supreme Court did yesterday was they stayed the preliminary injunction that had been issued by the court in the Eastern District of Texas in the case called Texas Top Cop Shop. That was the one that you and I talked about in our last podcast. That preliminary injunction had been entered by the court on December 3, and it's the one that had gone up to the Fifth Circuit, had initially been stayed at the Fifth Circuit December 23, then the Fifth Circuit reversed itself on December 26, so the injunction came back into force. The Attorney General had taken that decision up to the Supreme Court New Year's Eve. There had been briefing in the Supreme Court, and then that order came out yesterday. So what the Supreme Court did was they stayed the injunction, so that particular injunction is no longer in effect. There was no opinion by the court, so we really don't know what the rationale was. Was it on the merits, or was it just that the injunction scope was wrong? We don't know. Justice Gorsuch gave us a concurring opinion. Justice Jackson gave us a dissenting opinion, and that took care of the injunction. Now, for a moment, and you can watch all the people who write on LinkedIn, everyone said the CTA is back again. Well, that was correct, except for another case that had come up that had kind of been under the radar, and that's called Smith versus Treasury. That was a case also filed in the Eastern District of Texas in front of Judge Kernoodle, a different judge than the Texas Top Shop case. The Smith case is basically the same issues. The plaintiffs there are Texas residents who claim that the CTA is beyond the Congress's commerce powers. And the judge in that case had issued, again, another universal injunction, this time on January the 7th, enjoining the application of the CTA to the two parties to that case, but then also purporting to stay the effective date of the regulations. And this is being interpreted as another injunction against the CTA on a universal basis. Whether that actually is the case or not, there's a question on that. So by about noon Eastern time today, FinCEN was saying on its website that as a result of this outstanding litigation, the CTA is not yet in force. Therefore, parties may follow voluntarily, but none of the CTA's deadlines are in effect, and no one can be fined for failing to comply with the CTA. That's the FinCEN statement as of today, January the 24th.
At what time?
Roughly noon Eastern.
All right. Because we're recording this at roughly 1 p.m. Central. So it
could all be up for.
So could you tell us a little bit about this second case? Because I'm not sure we visited about it on this podcast.
We did not. So the Smith case involves two plaintiffs that are residents of the state of Texas. They both have operating businesses in Texas. And according to Judge Kernoodle's opinion, they do not conduct any interstate commerce. So on that basis, they argue they should be relieved of having to comply with the CTA because they have no interstate contacts. And so the first 33 pages of the opinion basically tread the same ground as we saw in the Texas Top Cop Shop case relating to the scope of the Commerce Clause. And at the end of 33 pages, the judge enjoined the application of the CTA to these two specific plaintiffs. But then on page 34 of its opinion, the court kind of heads off in another direction. And the court says, we're looking at the regulations that were adopted by FinCEN under the Administrative Procedures Act. And under Section 705 of the Administrative Procedures Act, the court says, we are empowered to issue all necessary and appropriate process to postpone the effective date of an agency action or to preserve the rights pending conclusion of review proceedings. And on that basis, having concluded that the CTA were fictional, the court says that therefore the regulations are also improper, and therefore the court, I will read the language exactly to make sure I get this right, the court stays the effective date of the reporting rule, 31 CFR 1010.380, while this lawsuit is pending. Now, this has been interpreted to be a universal injunction against the enforcement of the reporting rule, but I'm a little puzzled by this because the effective date of the reporting rule was January 1, 2024. And by the time this court's order was issued on January the 7th, 2025, it had been in effect for over a year. So I don't understand how that's staying the effectiveness prior to the implementation of a regulation under the APA, but admittedly, that is not my area of expertise. And given the way FinCEN is interpreting this as a universal injunction against the law, I suppose that's what we're dealt with. It remains to be seen what's going to happen next.
Were you able to read any of the concurrences from the original opinion?
From the Supreme Court's opinion?
Yes.
Yes. So that was, of course, the Texas Top Cop case, not the Smith case. There was one concurring opinion I saw, which was Justice Gorsuch, where he repeated his argument from Labrador versus Poe, that we talked about on the last podcast, which in his view is that there should never be a universal injunction on the constitutionality of a law, that the district court should limit their injunctions as to the parties before the court. Now, interestingly, in Labrador versus Poe, Justice Gorsuch wrote the concurring opinion then. He was joined by Justices Alito and Thomas. They did not join on this concurrence. In the Labrador versus Poe case, Justice Jackson was also dissenting. She was joined by some of the other justices, and she put forward a very different way of thinking about universal injunctions in which she distinguished between high-profile cases and other cases that were not so high-profile. In her dissent yesterday, she said that she would not have stayed the injunction because she felt that the government had moved too slowly in implementing the Corporate Transparency Act. It was a little bit difficult, though, to fully appreciate her dissent. She said that the government had waited 4 years to implement the law. That's not quite accurate. Of course, the law was passed, late 2020, early 2021. The rulemakings began in 2022. The reporting rule was final in late 2023. So roughly, 2.5 years from when the law was passed. It took effect January 1, 2024. So I don't see what the 4-year delay was all about right there.
So the commentary has been consistent, at least what I've read from law firms, is we don't know where this is going. Go ahead and fulfill the obligations. You have articulated that before. Would that be your advice to businesses again today?
I think that is the easiest way to go. Your choice, if you're a business owner, is go ahead and file this form, do what needs to be done, and get it over with. You can turn this television show off. You don't have to watch the drama anymore. The alternative is do all the work that you would need to do so that you're ready to file quickly, and then stay tuned and watch the drama continue to unfold. And at some point in the future, it may or may not be resolved. And if it is resolved so that you have to file, be ready to file on a moment's notice. To me, that's not a very convenient way to run a business. So I would suggest that people go ahead and file now and get it out of the way and turn off this very hard soap opera.
Could I maybe ask you to look down the road yet again and anticipate the arguments you expect to see, or do you simply see a recitation of what you saw at the district court and at the Fifth Circuit?
Sure. With respect to the Smith injunction, I really don't see any new arguments. I think it is basically the same case as Texas Top, and what this district court ought to do is take and stay the second half of its injunction, the universal piece, allow the injunction to remain in effect as to the two named plaintiffs, and then sit back and wait for the Fifth Circuit to issue its ruling in the expedited appeal of the Texas Top Cop case. That's what I would advise the court to do if it wanted to take advice from me. If it does not do that, I would expect that Treasury would appeal and ask for a stay of the Smith injunction in the same way that it asked for a stay of the Texas cop injunction, and it ought to get the same result because from the Supreme Court point of view, it is precisely the same issue, whether a district court ought to enjoin the CTA on a universal basis or not. There's nothing different in Smith than there was from Texas top, so you ought to get the same result.
So going down the road, do you think we could actually get a decision by the end of this term, or because of these sort of procedural shenanigans, we may be looking at a term of 2026?
Well, the procedural shenanigans, I think, are probably going to push the cloud of uncertainty out well into the future. You've got several different pieces here. You've got the Fifth Circuit piece. We know that the Texas case is going to be up for oral argument March 25. And, appellate courts can sometimes take months to issue an opinion after they have oral argument. So perhaps the Fifth Circuit gives us an answer in May, June, July, something like that. It could go one of two ways, right? It could send it back to the trial court, or it could uphold the trial court, in which case you've got an appellate court saying the CTA is unconstitutional. At the same time, we have the appeal in the NSBU versus Yellen case that has already been briefed and argued before the 11th Circuit. That oral argument was back in November, I think. And that ruling could come out any day now. Again, could go either way. Probably the most well-briefed of the other cases is the Community Associations Institute case, which I believe is going to go up for appeal in the Fourth Circuit. I have not checked the docket recently. I don't think it's been briefed yet. There's no telling how quickly the Fourth Circuit may rule. And from a Supreme Court point of view, they don't want to act until at least two circuits have weighed in. So if I'm on the Supreme Court, this is feeling more like a 2026 activity for me than a 2025 activity, apart from all of the injunctive interlocutory appeals.
Jonathan, what happens if we have a true circuit split in terms of the injunction?
Well, what happens on a practical basis? We'll have to see what FinCEN does, but that would really make the issue ripe for a decision on the merits by the Supreme Court. And those are the decisions that the Supreme Court, that's what those guys live for, to resolve those disputes. But that's the judicial playing field. And the political playing field is also about to shift underneath our feet, and that could make things even more interesting.
Well, for those who may not remember, the CTA came out of the AML law of 2020, which is part of a bill overridden by Congress of President Trump's veto on January 1 of 2021. So at least on that date, we had full Senate support for the CTA, or at least the law which promulgated the CTA. Do you see that support lessening?
Well, it's fair to say that there is some Republican resistance to the CTA now. There was a bill introduced in the last Congress that would repeal the CTA, introduced by a Republican. There's been another Republican repeal bill introduced in the House already this term. But the Republican majority in the House is very thin, so you'd have to have near unanimity to pass that bill. I don't see any appetite on the Democrat side to repeal the CTA. And the Republicans do not have a supermajority in the Senate, so they would have to get a number of Democratic votes in favor of repeal. And I'm a little bit skeptical whether that will happen. I'm also not really sure that it's really in anyone's long-term interest to repeal the CTA. Even if you don't like the burden that comes from having to file, there was a good reason for this law. And that is that more than 100 other countries have already introduced transparency into their financial systems in order to fight money laundering. The United States stood alone among industrialized nations for the lack of corporate transparency in its own system. And that's one of the reasons why we had such an acute money laundering problem in the United States. And if I were honored to give advice to the new administration, I would say that after campaigning on the hope of fighting drug trafficking and human trafficking across our borders, one of the best ways to fight that trafficking is by choking off its lifeblood, which is the ability to launder money. So what I would encourage the administration to look at is an administrative adjustment to the Corporate Transparency Act that would make it slightly less burdensome on business, but equally effective at fighting money laundering. And that's something that the new administration could do simply by regulatory change and without the need of getting another vote through Congress.
Jonathan, about the only thing that I can say with certainty is you and I are going to be visiting again. My only question is how soon?
You're probably right about that, Tom.
But I wanted to thank you again for jumping on this almost at a minute's notice. And between the time you agreed and we recorded, things changed even more. So
All true.
crazy. Well, thanks again, Jonathan. I look forward to visiting with you again.
Sounds great, Tom. Look forward to talking to you.